Good. Good evening, everyone. So glad to have you joining us. I want to get started. I know it's exactly 7 o'clock. I want to thank you so much for joining us this evening for our webinar, Wills 101, What Lawyers Wish You Knew. I'm Deborah Botter as Senior Director of Gifts and Estate Planning here at the Oakville Hospital Foundation, and I'll be your host for this evening. Our presentation is going to run about 40 minutes, and we'll have 20 minutes allotted for a Q&A session at the end. If you would kindly submit your questions in the Q&A box that's at the bottom of your screen, we will look at those at the end of the session. We'll be recording this session, and we will send you a link to this session in the next day or so afterwards. And we would like to have your thoughts, and so when we send you the link, please reply to the email because we love to hear your thoughts on the session this evening. Your cameras and audio have been turned off, but again, I encourage you to put your questions in the Q&A. I'm pleased to introduce our speaker at this time. It's Michael Vokes of Vokes Pettinato law firm. Michael has been practicing law in Oakville since 1979, and as of 1995, he became one of the founding partners of Vokes Pettinato law firm. He and his wife, Margaret, have been raising their family since 1985 here in Oakville, and he's been a wonderful resource to us here at the Oakville Hospital Foundation. Please help me with a warm welcome to have Michael begin our session. Michael.
Thank you for that introduction, Deborah, and thank you to the Oakville Hospital Foundation for inviting me to speak tonight. I know that some of you in this session probably already have wills, and some of you don't. So I'm going to be speaking hopefully to provide information for those of you that don't have wills, and at the same time providing some refresher information for those who already do. The first thing I want to do is talk about some popular myths regarding wills, things that I've encountered in my practice over the years. And I think we probably all have seen movies or television programs or seen plays where one of the important characters, usually a very wealthy character, has passed away, and the family and loved ones all meet in the lawyer's office for the lawyer to read the will to the beneficiaries. In reality, that just doesn't happen. None of the jurisdictions in Canada require that sort of process. And in my career, I've never heard from my colleagues that they ever went through that. Also, in fictional presentations, you'll see the lawyer mention something like, to my nephew, Michael, who never understood the value of $1, I leave $1. Well, that never happens. The will is not a platform for character assassination. And it also, it calls into question the sanity of the person who wrote the will if they're going to be writing all sorts of asides in the document. So that just doesn't happen. When people think about doing their wills, sometimes they'll say, well, you know what, I'm not ready. I want to do it, but I'm not ready yet because I really have to sit down and make an inventory of all of the items that I have, all my properties. And in actual fact, it's not what you have today that counts. As far as a will is concerned, it speaks from the date that you pass away. So it's only the assets that you have when you pass away that are handled by the will. And since we all will acquire and dispose of things during our lifetime, it's not necessary to itemize things before you make a will or in the will itself. You should instead think of what you will have when you pass away as it's not, you don't know what the details are, what the specific items are, but it's going to be a pile of value. And that should be the start point. So virtually any adult person can make a will. And if somebody was to ask me what is the best time to make a will, I would say the best time is now, while you're thinking of it. So I want to get into some basics about what wills do and don't do. And to begin with, the will is a document which only provides authority for assets that are in your own name when you pass away and don't pass by some other means. So an example of assets that would not be dealt with in your will are RSPs, RIFs, if you're beyond the RSP age, TFSAs, life insurance policies, and jointly owned assets. And the reason why those are not included is because in the case of RIFs and RSPs and TFSAs, they all provide a beneficiary designation that you can make when you set the asset up. For life insurance, it's the same thing. You can designate a beneficiary of your life insurance policy to receive the proceeds of the life insurance when you pass away. With jointly held assets usually carry with them the right of survivorship, which means that when the first joint owner passes away, the surviving joint owner simply has to have that person's name removed from ownership. And usually all that involves is providing who's ever in charge of making that change with a copy of the person's death certificate. At this point, I want to digress just a bit because in talking about RSPs and TFSAs, it's important, and this is one of the few tips I'm going to give you that may save some money on estate administration tax. And that is, you should from time to time review with the plan provider, the entity that carries your RSP or your TFSA or RIF, you should review with them your beneficiary designation. Many times people, when they set up the plan, will designate their spouse or a loved one as the beneficiary. And years go by and they never address it again. If the loved one were to pass away before you, then that beneficiary designation essentially results in one of two things. Either the asset will become part of the deceased person's estate, so they won't get to use and enjoy the benefit of it. Or if the deceased person, in the case of a spouse, was leaving everything to you, it'll come back into your estate. Now, estate administration tax, what we know generally as probate fees, those are calculated on the value of the estate at the date of death. So things which would not be included in that base amount subject to tax would be RIFs, RSPs, and TFSAs that go to someone as a result of a beneficiary designation. So in the event that your beneficiary designation that you made when you set the plan up is no longer effective because the beneficiary has passed away, the asset will come back into your, potentially into your tax base for probate fees. So the way to avoid that is to contact the plan provider, let them know you want to review your beneficiary designation, and tell them you want to make a contingent beneficiary designation. So that term, contingent beneficiary designation, describes who you want to receive the benefit of that plan in the event that the first person passes away. So your first name beneficiary, you're planning for the contingency that they will pass away before you do. So if you make arrangements with your plan provider to review your designation, let them know it's a contingent beneficiary designation you're thinking of. For example, if it was me who was contacting my provider, I would say, I know that I've designated my wife as my beneficiary on my TFSA. I'd like to do a contingent beneficiary designation so that if she passes before I do, my son would be the beneficiary of the TFSA. I only have one son, so that's what I would be doing. Moving on away from that, I did mention that the only things that the will deals with are things which are in your name when you pass away, your name alone. And the will provides a form of authority for somebody that you name in the will to deal with the administration of your estate, which means essentially paying debts that you may have during your lifetime, paying taxes, and then distributing what's left over to the people that you name in the document. The formalities surrounding the creation of the will are important. So in Ontario, and wills are always provincial in terms of the government authority that deals with them. So if you're an Ontario resident, it's an Ontario court that's going to deal with administrating the administration of your estate. So in Ontario, we recognize two types of will. One is a will that's executed, meaning signed, in the presence of two adult witnesses who shouldn't be beneficiaries, two adult witnesses who are present at the same time as you when the will is signed. That will can be typewritten, it could be handwritten, it could be done by computer, but it has to be signed in the presence of two witnesses. Now, we also recognize something called a holograph will. And a holograph will is a will that is written in your own handwriting. That's key. It has to be in your own handwriting. It can then be signed by you. It doesn't have to be witnessed. It is a valid will. So in answer to a question I get sometimes, do you need a lawyer when you're doing a will? Well, the answer to that question is no, you don't need a lawyer. There's a famous case from Saskatchewan that I first learned about in law school many years ago, where a farmer was out working his field with a tractor, and he happened to be on a hillside, plowing the hillside, when the tractor rolled over on top of him and pinned him. And realizing that he probably was not going to survive, the farmer had the presence of mind to scratch with his pocket knife on the fender, "Everything to my wife." And then he made a mark. And ultimately, that section of the fender was admitted to the court in Saskatchewan as a holograph will. It met all the requirements. It was in the will maker's own hand and signed by him. It didn't require witnesses. Now, if you ask a lawyer, can I write my own will? The answer is always going to be yes, of course, that's perfectly legal. But if you were to follow that up by asking the lawyer, is it going to be adequate to do what I want when the time comes, you would probably not ever get an answer that says anything more than, I can't tell you. I don't know what the future holds. So Certainly you can do your own will, but the danger in doing your own will is that you'll miss something that's important. And I think that everyone wants to make things simple and easy for the people that they leave behind, the people who are going to be doing the work of administering their will. And so it's important when you make your will that you do a thorough job. And that thorough job should involve essentially three tasks. The first task and the second task are extremely important to you, the will maker. And those tasks are appointing someone who's going to do the job of administering the estate. We call that person the executor or the trustee. They're executing your will and they're carrying out the trusts contained in your will. So the appointment of your executor and trustee is something that you should put a significant amount of thought to. It is not a mark of affection. Being someone's executor is a job, and you should pick someone who is willing to do the work. So it means definitely talking to them before you simply appoint them. You should acquaint them with what you believe the nature of the job will be. You should continue to have a dialogue with them from time to time. It's important also that you pick someone who may be significantly younger than you are, because you want someone who's going to be fairly vigorous when the time comes to administer the estate. If you are thinking of appointing family members, it's, as I said, it's not a mark of affection. So if, for example, your family consists of, say, 3 adult children, appointing all 3 adult children as executors is something that certainly you can do. Is it something you should do? Well, in a lot of cases, that depends entirely on the family dynamic. But in practical terms, your executor should be somebody who is geographically close at hand. They definitely should be somebody, if possible, who lives in the province of Ontario. You want the person you appoint to be a good communicator, because they're going to have to be dealing with the beneficiaries of the estate. And they are also going to be transacting business on behalf of the estate with various people. There aren't any real sort of job qualifications for an executor, other than they should be, as I said, a good communicator. They should be somebody who is younger than you are. They should also be someone who knows their limitations and is prepared to reach out and seek assistance from experts or professionals if that's warranted. It is possible too, if no one springs to mind when you are grappling with the question of who do I want to appoint as my executor. All of the major banks in Canada have trust companies that are, as part of their function, that act as executors for people in their estates. And there are some urban myths about appointing trust companies, which I'd like to put to rest. The first is that trust companies charge an arm and a leg for the service. That isn't true. Trust companies have it's their core business to administer estates. So there's no learning curve for a trust company. There is a perpetual pool of people to continue. So you're not concerned about whether or not the person you've appointed is going to survive you, because the trust company will always be there. Also, if there is anything that's sensitive about the provisions of your will, that may or may not cause interface with one of your beneficiaries. The trust company is the perfect executor in that circumstance because there's no emotion involved, on their part at least. And it also doesn't create friction with the other beneficiaries if the trust company is the party to whom an individual beneficiary has to interface. Regarding fees, every person who administers an estate is entitled to charge a fee for doing the job, because as I said, it is work. And there's nothing legislated regarding a fee scale. The fee scale comes about from the practice of judges, the current practice of judges when they are asked to pass a set of estate accounts and determine whether or not the fee requested by the executor for that service is reasonable or excessive. And so the general fee scale for executors now is 2.5% of the assets of the estate at the time the person passed away, and another 2.5% of the value of the assets that are left after debts and taxes and other administrative costs, the amount that's left for distribution to the beneficiaries. There are other add-on fees for investments made, for care and control of assets, for receipts, but basically it's 2.5% and 2.5%. Now, trust companies know that, and so usually the trust company will have a fee scale which is slightly lower than that. And trust companies will always have the will maker sign a fee agreement so that the fee the trust company charges is locked in at the time the will is done. And then the beneficiaries know that the fees are not going to go up over time and that it was a fee that the will maker agreed to. So the circumstances when a trust company would come into play as an executor, a good choice for executor would be when either there's nobody that is in the will maker's circle of friends or family who is willing to do the job or able to do the job. Also in circumstances where there may be potential disputes between beneficiaries. This often happens in families, and one of the ways to deal with that is to have a neutral party act as executor, and that's the perfect time to appoint a trust company. So the other possibilities, of course, are to appoint family members or friends to fill that job. I would always suggest that you want to keep that person up to date in terms of things like your passwords, where your assets are located. They don't perhaps need to know specific amounts because, of course, those will change between now and the time you pass away. But these are important people for you to keep up a dialogue with and to provide as much information and detail as you possibly can so that they will be able to do the job when the time comes in an easy and efficient, both in terms of time and money manner. The second part of the will, the part that probably we think most about when we think about making our will is who's going to get my stuff? Those are called dispositive clauses because you're disposing of assets. So the thought that goes into that part of the will, certainly our first choice is always going to be to benefit our family members, our loved ones, those that are closest to us. And there are very few parameters surrounding who you can and cannot leave your estate to in Ontario. The first thing to remember is there is no law that says that you must leave your estate to family members. You don't have to leave your estate to your children, for example. Um, a lot of times I will have clients come in and they will either um, recount directly to me something that one of their adult children has said that indicates that they think they're entitled to a share in their parents' estate, and that is not the case. There are some obligations when you make your will. Certainly for married couples, there's an obligation to leave at least as much of a gift in your will to your spouse as will enable the value of the spouse's individual assets to equal the value of the assets of your assets when you pass away. You're also obligated, your obligations, your legal obligations don't die when you do. So if you are under any sort of legal obligation to pay, for example, support for children or for a divorced or separated spouse, those obligations continue and would have to be dealt with before the amount is determined that could be available for distribution to your beneficiaries. Other than that, you can leave your estate to whoever you want. And as I said, of course, we want to consider our loved ones and make sure that they're well looked after. After debts and taxes are paid, and that's what's left over for distribution, it's possible, and it's an opportunity. This is the first opportunity that you have to start giving things away. And you may want to give away specific items, specific amounts of money, or specific investments or bank accounts. And certainly the will is a vehicle for doing that. It's also an excellent opportunity to make a charitable gift, for example, a gift to the Oakville Hospital Foundation. When you give a gift to a charity, it doesn't have to be your entire estate. It can be a specific amount of money. It can be a specific asset, for example, a bank account or an investment account. When you make a gift to a charity like the Oakville Hospital Foundation, aside from receiving a tax benefit, the intangible benefits are it's your way of saying thanks for treatment that you've received or treatment that a loved one has received at the Oakville Hospital. It's also, it's easier to make a gift in your will because it doesn't put a strain on your ability with respect to your assets to make sure that while you're alive, you're not cutting yourself short by making a charitable gift. Once you have thought about and made whatever gifts of specific assets you want to make in your will, what's left over is known as the residue of your estate. And the residue of your estate, it can either go all to one person or one entity, or it can be divided up between different people or institutions. And wills are all about certainty, and they're also about empowerment. So your will should always, because none of us can predict when we or a loved one is going to pass away, your will should always have at least a plan A and a plan B built into it. The purpose in having the plan A and the plan B, besides the obvious, is that if either your plan A or your plan B does not work out, then you've got hopefully the luxury of some time to think about making changes so that you'll have a new plan A and a plan B. And the areas where you want to have at least a plan A and a plan B are the appointment of an executor and in distribution of your assets, who's going to get your stuff, so to speak. If your thoughts are that you would like your children to be the beneficiaries of your estate, 10 minutes to go. Okay, I'm rambling on here, and I've been told I've got 10 minutes to go. I'm hoping that what I'm saying may stimulate some questions in the question and answer period. Stepping back a bit and summarizing, a will is a document which creates authority in someone to carry out the job of administering your estate. It also indicates who you want to benefit by receiving your assets after debts and taxes have been paid. And those are the only two parts of the document that should be of real concern and focus for the will maker. The third part of the document, and the document that takes up most of the ink, is what are known as administrative provisions. Those are powers and authorities and directions that you're giving to your executor in the document to enable the executor to do the job that they have and in the most efficient manner possible. And you should think of them as tools in a toolbox. If the tool is required, you want to have it there. If it turns out at the end of the day that that tool wasn't required, then the fact that it's in the toolbox is not a bad thing, it's a neutral thing. So when you do your will, your administrative provisions should contain a series, a complete series, so that as I said, so your executor will be able to deal with your estate in whatever shape or form it happens to be. The will does three jobs alone. It, as I said, it appoints people to do the work. It says who's going to get your stuff, and it provides administrative provisions. There are a number of terms that are used in wills, and one final thing I want to say, since we're getting close to the end, is why is it that wills, when they're prepared by lawyers, seem to use wording that we don't use in conversation? The meaning of the provisions is obscure in a lot of cases. Why is that? Is it because lawyers want to keep wills as mysterious documents? The answer is no. The reason that we do that is because we want to make sure that the meaning in the document is clear to someone you hope never reads your will, and that person is a judge. English is an imprecise language with a lot of examples of the glass being half full and half empty. And your will is not a document that you want to have provisions that are fit that characterization. And so we cling to wording from provisions that have been tested in the past in court, and their meaning is crystal clear. If the will were to contain provisions that were written so that you and I might feel more comfortable with the language, having more modern ways of expressing things, then in all likelihood, if there was a question about specifically what did we mean in our attempt to craft something that was concrete and not controversial, your estate might be subjected to expensive court proceedings to have a judge determine whether or not the glass is half full or the glass is half empty. So when a will is done by a lawyer, the lawyer is actually acting as an expert in cutting and pasting things, not in unique draftsmanship. You don't want an author, you want somebody who knows the right things to put into the document so that in the event, when the time comes, it's not ever going to see the eyes of a judge. Wills should never be documents in which you, 5 minutes, okay. Wills should never be documents in which you want to teach someone a lesson or settle a score, because they don't have that effect. And this comes about most often in families where maybe one of the children either hasn't been as successful, hasn't thrived, and so the parent believes that they need more help, and the place to do that is in the will. Or if a child is estranged from his or her parents, and the parent thinks that by cutting the child out of the will or providing them with a smaller share in the estate, that it will be teaching a lesson to the child that they should have cared more for their mom or dad. Um, in actual fact, the net result of that is the child never learns a lesson. If the child was estranged to begin with, they're just going to be more estranged. Not only that, but it drives an everlasting wedge between that person and the rest of the family. In my career of more than 4 decades, I've had to appear as a witness in court in 3 cases, and only 3 cases, thank goodness. And all of those had to do with situations where parents treated their children differently from one another and compounded that by not letting the children know in advance what they were doing. Most of us think, regardless of our relationship with our parents, that they love us the same. And so when anything happens uh, that shatters that, there's going to be trouble. I don't want to end on that note. I want to end by suggesting that um, it's always a good idea to look at your will once in a while. It's not going to require change because of changes in the law. It will only require changes if the people that you've named in the document have either changed in your affection or if something has happened to them and they're no longer in a position to do the work or receive your stuff.
Hi, Michael. Thank you so much.
Okay,
That was great. We very much appreciate it. You covered a lot of ground, and I just have to say, I'm so very glad that we've recorded this so we can look back on it and review it a little bit because you've covered a lot of questions there. We do have several questions that I want to run by you.
great.
Our first question is, can I do my will in the absence of a spouse?
Okay, so the answer to that question is yes, you can do your will in the absence of a spouse. What you can't expect is if you and your spouse have gone to see a lawyer and had your wills done, you can't expect to come back to that same lawyer in the absence of your spouse and have your will redone. Because when spouses go to a lawyer to have wills done, there is an unspoken expectation that each one knows what's going to be in the other one's will because they've both been attendant at the meeting. They've both expressed the same wishes. And so if in circumstances where someone were to come back after I'd done their wills and say, look, I want to make changes to my will. I don't want my spouse to know. I'd have to say, I'm sorry, I can't do that. The only circumstances in which I could make a will for you would be if your marriage had permanently broken down, if I advised your spouse that you'd come to see me to make a new will, or if your spouse had passed away. But certainly, getting back to the original question, each individual can make their own will. You don't have to make it with your spouse if for some reason you choose to do it on your own.
Okay, thank you. Another question we have is, our primary residence has been in Ontario since 89, but in 2019, they bought a condo in Halifax.
Okay.
But since spring of 2022, it's been investment property only. So given that wills are provincial, as you emphasized in the beginning, how do we approach our will vis-a-vis the Halifax condo?
Okay. So first of all, um, in this day and age, everyone is, or a lot of us are travelers. And for the longest time, that's the way human beings have been. We've been travelers. And so over the course of history, um, there's been a body of law built called private international law. And one of the areas that of the private international law deals with is uh, wills and estates and succession to assets around the world. So whatever jurisdiction you live in, your will, so if you live in Ontario, the will that you do here is meant to be global in effect. It's meant to cover the assets, your assets, all around the world, wherever they are located. There are a few stipulations to that. And one of the stipulations is that succession to land, real estate, is always governed by the province in which, or the country in which, the land is located. So if, and Nova Scotia would be no different than Ontario in this respect. So if the land, for example, though, was located in some other country, if that country had a set of laws that dictated to whom you had to leave your estate, and some jurisdictions do, then the law of that jurisdiction would govern what happens to the property when you pass away. If the questioner was concerned about the mechanics of dealing with a transfer of that particular asset, certainly there are um, reciprocal accommodations between Canadian provinces. So if the deceased person's estate was dealt with in Ontario, and let's say that the will was probated in Ontario, then it's just a procedural matter to have the Ontario probate registered in Nova Scotia to allow the transfer of that deceased person's asset land in Nova Scotia. Not a big problem where the land in question is in different provinces in Canada.
Okay. A secondary part to that question is, the person has a son who is in Rochester while the
Yep.
daughter lives in Toronto. What are the implications of that for the will?
Okay, I'm glad that that's been raised. My one and only son lives in Brooklyn, New York, so I'm in the same boat. And once again, we get into private international law and trust law. And first of all, most wills are trust wills. And a trust will is simply a will in which there has to be some mechanism, some legal basis for giving somebody authority. So, Deborah, if you and I were in the same room and I handed you a pen and I said, put that in your pocket, put it in your purse or your briefcase, I want you to have the ownership of that pen. That's one form of giving ownership changes in those circumstances. Okay. If, on the other hand, I gave you the same pen and I said, I don't seem to be able to write with this. I think it's out of ink. Would you please replace it with either another pen or put a refill in this pen and return it to me? I've still
Mhm.
given you the pen, but I haven't given it to you with the expectation that ownership will change. I've given it to you with a job to do. And that's all that a trust is. A trust is just another word for a job or a task. Okay. So when I gave you the pen, the,
Mhm.
the trust was to replace the refill or replace the pen. I'm giving it to you to do the job, so you're the trustee. So all wills are forms of trusts, trust wills, because one of the parts of the will that gives authority will be a phrase, something to the effect of, I give all my property to my trustee upon the following trusts. So that means, here's your authority. I'm giving everything to you, but for the sole purpose of carrying out some jobs which I'm going to enumerate. And so those jobs would be pay debts, pay taxes, and distribute my estate. Okay, so getting back to the original question. Since all wills are trust wills, they are subject to trust law, the law of trusts. And the law of trusts on an international basis, Canadian law, and for example, you mentioned Rochester,
Mhm.
American law, it's the same. The law, the trust is located for the purpose of the jurisdiction of the trust where the trustee is located, where the decision maker is located, and not where the trust assets are. So for someone like the questioner or me, who have adult children living in the United States,
Mhm.
if we appoint those people as our executors, we get into a situation where it adds, I don't want to say difficulty, but it adds to the process and the complexity of the administration, because it might mean that although all of the assets are located in Ontario or in the rest of Canada and subject to Canadian tax, and there are only two potential taxes, that's income tax and a state administration tax, it might also mean, depending on US tax law and depending on the size of the estate, that there might be US state tax payable. Now, that's one aspect to consider. Certainly, if the executor is resident in Rochester, New York, if that person is going to comply with US law, and we have to assume that they will, there are reporting requirements added on if they're going to act as executor, even though there might not be tax uh, implications in the US for that. Add into that that Ontario courts have jurisdiction only over things within Ontario. So if the executor is outside of the province of Ontario, Ontario courts have no jurisdiction to compel that person. And in effect, if they were to grant probate to a person who lives outside of Ontario, they would be giving that person license to take all the assets, remove them from the province, and the court would be powerless to, if you will, police the administration of the estate. So to start with, foreign executors, meaning in this case, limited case, executors living in the United States, are required by Ontario courts to post a bond. Essentially, the amount of the bond would be twice the value of the estate in order to be able to be appointed as executors. Now, to put the whole thing in context, if it's a family situation and if this particular US resident, son or daughter, is only one of several others, then maybe the consideration should be to appoint the ones in Canada, or at least appoint them as a group so that the US resident is not the sole decision maker. Now, as far as the bond is concerned, if, as I said, it's a family situation and the will maker's son or daughter and siblings, if the other beneficiaries are all in agreement, then maybe they can get the bond dispensed with. So it affects executor appointment. It does not affect entitlement to receive a share in the estate if your son or daughter lives in the US.
Okay, all right. You spoke to this a little bit already, Michael, but how often should a will be updated and what are the considerations and costs involved?
Okay, so let's deal with the costs first of all. So you're not buying a car, you're not buying a TV set. They aren't consumer items where you can do some, comparison shopping and get a solid idea of what the base is going to be. What you're getting is you're getting a personal service. So the cost is going to be, there's probably going to be a broad range of choice involved in the cost of it. So if you were, for example, I would expect that um, and not trying to, I mean, the danger of giving a number is that people get that fixed in their mind and think if they hear higher, it's outrageous or lower, it's a deal. All I can tell you is that most lawyers that prepare wills like to be compensated on the basis of time, effort, and thought that goes into it. So you are probably looking at more than 1,000, less than 2,000 to
Oh,
to do a will. And
okay.
depending on your relationship with the professional in question, maybe it would be less, maybe it would be more. Certainly, the more complex the document, I would expect the higher the fee.
Okay.
Uh, and in terms of how often should you look at your will, by its very nature, it's designed to be a document which can survive for decades without revision. Because as I mentioned when I was talking earlier, it shouldn't be asset specific. It's not dealing with stuff you own now. It's only dealing with what you own when you pass away. So what you own and what you acquire shouldn't necessarily shouldn't necessarily have anything to do with revising the document. It's meant as something which will last a very long time. You should give attention to making changes to it if something changes in your relationship to the people that you've named in the document. The person you'd counted on, your best friend's nephew or son who was going to administer your estate has just accepted a job in Australia. Maybe you want to look at appointing somebody else. Or
Okay.
the people that you've named have, you know, to receive things have passed away. You may want to make changes. One question that hasn't been asked, but I'm going to bring it up now, is what happens when grandchildren are born? So my wife and I did our will when our kids were small. They're now adults, and now we've got grandkids. Do I need to make changes to deal with leaving something to the grandkids? Well, first of all, you'd have to look at your will. Most lawyers try and deal with contingencies regarding not only you passing away and when you pass away, but contingencies regarding whether or not your heirs will be alive at the time you pass away. So when a new grandchild is born, I often get calls from people saying, "Hey, you did my will. I know it goes to my wife. If my wife's not around, it's divided between the kids. What about the grandkids?" Well, short answer is you don't have to make changes to your will to make sure your grandkids are included if they are in line to receive something. So the normal situation that most people want is, well, if my son is alive when I die or my daughter is alive when I die, they would get the share in the estate. And it's only if they die before I do that I would want the share of my son or daughter to go to my grandkids. Here's another thing, something to think about, two things to think about. When you leave things to people who are under the age of majority, under the age of 18, there will be provisions in the will for dealing with the orderly management and disposition of those assets to spend the money until they become adults on their education and advancement in life, which is what you would want to happen. If you leave a specific legacy, meaning a cash amount, to your grandchildren, and I have people come to me and say, you know what, I'm doing quite well, my family's looked after, I'd like to leave $125,000 to my grandkids, so that they won't have to worry about their education, and they will be able to maybe buy a house or put a down payment down. Well, that's great. You know, adopt me. I'd love to be one of your grandkids. But every child who is under the age of 18 can only receive a very limited amount of money on an annual basis. I think it's like $5,000, or it's low. If you leave an amount to someone who's under the age of 18, if the amount exceeds $35,000, all of a sudden a public civil servant named the children's lawyer gets involved in overseeing how that money is invested. And as soon as you go over that $35,000 limit, you can't be leaving that gift to be managed and administered by the parents of the child. It either has to be administered by the executor of the estate or paid into court. So something to,
Wow.
and the finale to that is, the final point on that is, talk it over with your executor, because if somebody was willing to do the work thinking it was a 1-year job, and suddenly you indicate that you've got a 2-year-old grandchild who's supposed to receive money when they become an adult, suddenly the estate's going to be open for 16 years, and that is going to mean annual reporting. It may mean management decisions to be made, checks to be cut from time to time. It may not be something they want to sign on for.
Michael, thank you. I've got two questions left. We've got to make it really quite brief.
Okay.
One is, and I believe you may have touched on this, can an executor be a beneficiary?
Yes. An executor
Okay.
can be a beneficiary.
Okay. The last question is, can you tell us more about the tax benefits of gifting to charity in a will?
Okay, well, I'll be as brief as I can on that one. And
1 minute.
Yes, you speak to Deborah about that, because she can give you detail, especially when you indicate the nature of your specific gift. But there are income tax benefits to making a gift to a charity. If you gift something to the charity, and once again, this is something that Deborah can get into detail about, you're reducing the amount of tax that is paid on your final tax return, something called the terminal return, covering the period in the year. So if you died in 2025, it covers the period from January 1, 25 to the date of your death. That's known as the terminal period, or stub period for your tax return. The benefit of giving a gift to a charity would show up in reducing your tax in that final return.
Okay, thank you very, very much. Michael, you really covered a lot. If we have any more questions, I think we've covered all the questions. If not, we will certainly answer. I will get Michael to answer them afterwards. And when I send the link to everyone, I will answer those questions in that link as well. Again, thank you so much for coming out tonight. We very much appreciate it. Michael, thank you so much for giving us your time and your energy and your resources. We very much appreciate it as well. Everyone, thank you again. Take care. Michael, thanks.
Thank you.
And we will say goodnight for now, and we will send that link to you in the next day or so. Thank you, everyone. Have a good night.